And my name is Meria from Yemi Getachew Immigration Law Office. Today I wanted to talk to you guys about an important topic that we've been getting a lot of calls about, and that's the new public charge rule. But before I begin, I just wanted to state that today's video is for educational purpose only, and it should not be taken as legal advice, and it's not a legal advice. Now, a lot of you might have already heard about the new public charge rule, but might not know if it applies to you and how does it gonna affect you. If you already a green card holder, the new public charge rule does not apply to you unless if you leave the country for 6 months and more and you try to get readmitted into the United States. The public charge rule would not apply to you if you are an asylee, a refugee, if you're a U visa holder, if you are on VAWA or T visa holder. The public charge rule does apply to anyone who is applying for a green card as a spouse of a U.S. citizen, as a child, son or daughter of a U.S. citizen or permanent resident, as a brother or sister of a U.S. citizen, and trying to apply for a green card through an employer who petitioned for them. So the public rule would apply to you if you're applying for a green card through any of those categories. And it would apply to you if you're applying through the U.S. Embassy or if you're applying in the United States through USCIS. Now, a lot of you might have question about, well, how does this is going to affect me? When you apply for the green card, you have to be able to prove and show that you as the applicant will not get on certain government assistance or public assistance throughout the period that you are a permanent resident. Now, a lot of you might say, well, I've never used any public assistance or government assistance. Does this rule still apply to me? And the answer to that is yes. Regardless of if you have ever applied for any type of public assistance or government assistance, this rule will still apply to you, and you will still have to be able to prove that in the future you will never be using these certain type of public assistance or government assistance. And that involves the complicated forms, the documentation, a lot of documentation that has made things a little more complicated than before. Now, you might ask, well, I have applied for a public assistant before, or I'm currently receiving a public assistant or a government assistant. Does that mean that I will not be able to apply for a green card, or that my green card will be denied? The answer is it depends, not necessarily. It all depends on what type of assistant you applied for, when did you apply for it, what type of assistant are you currently on. So a lot that goes into it, and it doesn't necessarily mean that your green card will be denied. You will need to talk to an experienced attorney to be able to guide you through these process or the step and hold your hand through this process so that you will be able to get your green card. Because after the new public charge rule, the process of the green card has significantly changed, and it's no longer as simple as it used to be. At Yemi Getachew Immigration Law Office, we're here to help you guys with your green card applications, with your issues with the public charge, and even during the COVID-19, we're operating from our home. So give us a call or send us an email with your questions, with your application, and we'll be more than happy to help you with it. Our phone number is 408-292-7995, or you can also schedule an appointment at www.ethiopianattorney.com. Thank you and have a good day.